Thank you, Florian, for the presentation. Thank you all for attending this UPC aperitivo. This evening, I will discuss, along with Mario, a recent decision of the local division of Munich of the UPC for a case that was successfully handled by our colleagues of Meissner Bolte. The case is between the German company Brita SE against Aquashield Europe and others. The decision was issued in August, so a bit more than 1 month ago. The patent is a European patent relating to a valve actuating device for a water treatment system. Just a short background of the case. Brita, so the patent owner, is the producer of the so-called style filter system. It's a water filter system that includes a filter cartridge. So here we can see, here is the container, the liquid container, with a jug within the outer container. In the jug, there is mounted a filter cartridge, which now is outside of the container, but is to be mounted inside the jug to filter the water. The jug has a valve system called the perfect fit valve system on the bottom of the internal container. It's a normally closed valve, so it's normally closed, and it's moved to the open position by means of a valve actuating device that is provided on the bottom of the cartridge. We will get into more detail on the technical detail later in the presentation. The patent was filed in 2010, granted 2 years later, is in force in Germany, Austria, Italy, and France. An opposition was filed against the patent, but was withdrawn after the preliminary opinion of the division. The patent was first opted out, and then, of course, the opt-out was withdrawn before starting the action before the UPC. The defendant, the main defendant, Aquashield Europe, markets compatible cartridge, so it doesn't sell the whole system, but cartridges, compatible cartridges to be used, among others, with the filter system marketed by Brita. Therefore, Brita sued Aquashield Europe, as well as the distributors in Germany, Austria, Italy, and France, of the country where the European patent is in force, claiming both direct and indirect infringement, and we will focus on that later. The defendants counterclaimed for revocation of the patent due to lack of novelty and inventive step. Here, just to show some pictures of the, here we can see the valve at the bottom of the internal jug. This is a technical drawing showing how this valve is made. Here we can see the defendants, the assumed infringing product that was found to be infringing. It's a cartridge that on its bottom has here it's a partially ring-shaped element protrusion that acts on the valve to open it. So we can see from this picture that when the filter is not in its mounted position, the valve is normally closed, so there is no flow of water from the internal container, from the jug. On the other hand, when the filter cartridge is mounted, so is in its working position, the valve actuating device on the bottom of this cartridge opens the valve, and so, as highlighted here, water can flow from the inner container to the outer one. Here, just the main an overview of the main claims of this patent. As you can see, there were different levels of protection. Claim 1, independent claim 1, relates to the valve actuating device as such. It is defined as a valve actuating device of a valve designed, and here only some features are indicated, but we will show all the other features of this claim. So what is important is the device is defined as being designed to open the valve by exerting a force having a horizontal component. So a component of this force is directed horizontally. Claim 4 is another independent claim that claims a liquid container. So here we can see, so the one indicated with number 5, so 5, so the upper one where the filter cartridge is mounted. So claim 1 is directed to the liquid container that has an outlet opening, a valve arranged in this opening, and a valve actuating device designed to open the valve by, as recited in claim 1, by exerting a force having a horizontal component. Claim 12, in this case, is a dependent claim because it's a product claim that claims the combination of the liquid container according to any one of claims 4 to 11 plus the liquid cartridge. And the last claim 13 is a dependent claim depending on claim 12, and it adds that the valve actuating device is arranged on the liquid treatment cartridge. Let's move on. Okay, so these are the 4 main issues that the court addressed in its decision. Purpose, feature, and device claims, defense via auxiliary request, scope of exhaustion, and consequences of indirect infringement. It's not working, then probably, okay. Okay, thank you. Thank you. Regarding purpose features, here we can see claim 1 subdivided in its features in the decision of the court. Here we can see that most of these features do not relate to the valve actuating device, but to the valve. So the valve actuating device was defined as being able to operate, so to open a valve that has all these features. The valve comprises a movable shut-off body and a valve seat. The shut-off body is trapped in a valve chamber. It's movable in that chamber, both in the horizontal and vertical directions. The valve is located in the outlet opening of a liquid container of a liquid treatment device. And it is in the closed position when the liquid container is installed in the liquid treatment device. So all these features relate not to the valve actuating device, but to the valve. The only feature that relates to the device is feature 2. And it says that when the valve actuating device is attached to the valve in the closed position, it opens, so it's designed to open the valve, as I mentioned before, by exerting a horizontal force component. Just to highlight, here we can see this, probably it's not, but here probably, this is the valve actuating device. When the filter is mounted, this moves the shut-off body of the valve, and so it moves the valve from the closed to the open position.
No, l'altro.
Okay.
Accelera un pochino.
Okay. Regarding, so first there was an issue relating to what claim 1 was claiming, because according to the defendants, claim 1 was claiming not the valve actuating device as such, but a combination of the valve actuating device and the valve, because most of the features of that claim related to the valve instead of. But the court says no, claim 1 only protects a valve actuating device. The valve is only mentioned to define the purpose of this device. The purpose is to operate a valve that has some features. So what is important for the court is not the purpose, the structural features of the device, and the fact that the purpose only plays a role where the prior art is not suitable for that purpose. Probably it's clear if we look at what the court decided regarding novelty of this claim. In fact, claim 1 was considered lacking novelty over document D1, which is a document in the name of the same of the same plaintiff. This document show a cartridge having a sleeve on its bottom, and the court stated that this sleeve is able to operate a valve, even though, and so just for this reason, this document was considered as novelty destroying, even though this document does not even mention a valve, and even though this element, what the court considered to be corresponding to the valve actuating device, is not described in this document as a valve actuating device. So even though there was no valve, there was no indication of the function of this element, since this element was suitable for actuating a valve by exerting horizontal force component, this document was considered novelty destroying against claim 1. To defend the patent, the plaintiff filed several auxiliary requests, as it is provided for by Rule 31 of the Rules of Procedures. The rules state that the number of auxiliary requests must be reasonable. In this case, there were 16 auxiliary requests plus 4 additional requests. The court stated that most of these, because at the end the patent was maintained based on auxiliary request 16, so the last one. All the previous auxiliary requests were not considered valid because at least one of the claims of that auxiliary request was not valid. The court pointed out, as we also know, that amendments must comply with Article 84 UPC, so must be clear, and clarity has to be established if there is an amendment. So it's not simply the combination of granted claims. What is important for the outcome of this case is that claim 1 of auxiliary request 16 correspond to claim 30, so was claiming the combination of liquid treatment device, liquid treatment cartridge, liquid treatment device comprising cartridge plus container plus valve actuating device arranged on the liquid treatment cartridge. And then I will leave the floor to my colleague just to end. So since the defendants did not provide the whole system, but just a component of the whole system, there was clearly no direct infringement, but an indirect infringement played a role in this case.
Okay, thank you, Davide. First of all, I want to mention that also Davide has an aperitivo here. Only forgot it there. I'm not the only one. And thank you again to our colleagues of the EPLN für die Einladung. Wir freuen uns sehr, mit Ihnen zu sein. So going back to the exertion of right, of course, the defendants try to use this argument, but the exertion, as everybody probably know, occurs when the patentee put a patented product on the market, or the patented product is put on the market with his consent, and after that, the owner of such a product, so the purchaser, can use such product and also resell it. But in this case, and this was also the argument of the local division, basically we should make a distinction between maintenance and restoration of a product and the reproduction of a patented product, where only the maintenance and restoration could amount to an exhaustion of right, whereas the reproduction, so if I create a new patented product, these amount to direct or indirect, as we will see, infringement. So no exhaustion occur in the present case. Another interesting argument was the indirect infringement. As I mentioned, I reproduced the Article 26 of the UPC agreement. And in this case, of course, an indirect infringement is when someone who is not authorized by the patentee put on the market means relating to an essential element of that invention. So, of course, in the states covered by the patent, and with the subjective element, which is crucial, that these person knows or should know that these means are suitable for putting the invention into effect. Basically, the court addressed all the elements for indirect infringement. So the objective element, the territorial scope, the person was not authorized, the subjective elements, of course, in this case, the defendants were aware of the fact that the water cartridge was intended to use for the Brita carafes, for the Brita jugs. And interestingly, also, they gave an explanation of what can be considered an essential element. And here I reproduce, we only read the translation, the English translation, but basically, interestingly, the local division clarified that all features specifying the patent claim can be considered an essential element of the invention. So these apply regardless whether they are in the preamble or in the characterizing part of the patent claim. And this is very interesting in my view. It is irrelevant whether they relate to the core. I do not understand why they speak about core of the invention. One of my teachers said in the patent there is no core, there is no heart, there are only claims, but nevertheless. So what are the legal consequences? Interestingly, no unrestricted injunction has been issued by the local division because such water cartridge produced and merchandised by the defendants could be suitable also to be used with other jugs, with other carafes. So they say no unrestricted injunction, but warnings. You need to include warnings on the packages of such water cartridge containers. And in particular, these I reproduce the warnings. So you should clearly state that this liquid treatment device, that this cartridge may not be used with a liquid treatment device according to the patent, or you have to indicate that the liquid treatment cartridge is not intended for use for containers of the Brita brand with perfect fit valve. So almost an injunction, I could say, but not an injunction, but more a clear warnings to the consumers and to the other commercial entities. No contractual penalty, which was requested by the plaintiff but denied, and the defendants were obliged to provide the plaintiff with information about all the chain of commerce of this water cartridge. Interesting, last point, I almost ended because we just went a little bit long with our presentation, but okay, interestingly, the plaintiff also requested a declaration of an infringement, which is a corrective measures according to Article 64 of the UPC agreement, but the court said, no, you cannot apply these kind of corrective measures to indirect patent infringement, which is pretty strange, but I took notice of that, and I believe it was worth to telling you as well. Thank you very much again.